Okay. Hi, this is Josh Blackman. I am happy to host the Harlan Institute ConSource Virtual Supreme Court Competition. This is the second match of the day. Today we are hosting a petitioner team from Barefoot Sanders High School in Texas. We have Scott Calvillo. How are you, sir?
Hello there.
Very good. And his teammate is Arianna Jenkins. How are you today?
Good.
Very good. And again, my name is Josh Blackman from ConSource. I am happy to be joined by my associate from, I'm Josh from the Harlan Institute, and I'm happy to be joined by my colleague Sebastian from ConSource. How you doing, Sebastian?
Good morning.
Say it again.
Great.
Okay.
To be
All right. Well, thank you so much, Sebastian. Okay. The way this tournament works is that each team will get 15 minutes.
happy to be here.
Thank you, sir. Each team will get 15 minutes and also 5 minutes rebuttal. Since we only have a petitioner team, this will be a shorter match. I'd also like to thank their teacher, Mr. Seal, who's coached 3 excellent teams for our tournament. All right. Who's first, Arianna or Scott? Who will be beginning?
I will.
Okay. Counselor, you have 15 minutes. You can begin whenever you are ready.
Okay. May it please the court. My name is Arianna Jenkins.
Oh, I think, Scott, you're on mute. There you go.
And my name is Garcia Calvillo.
And together we represent the petitioner, the Espinoza family in this case. The question before this court is, does it violate the free exercise clause of the First Amendment to invalidate a generally available and religiously neutral student aid program simply because the program affords
Scott's on mute.
the choice of attending religious schools?
Because the petitioner will argue that it is not against the free exercise clause of the First Amendment to invalidate that fund, and that furthermore that the Montana Constitution is itself unconstitutional under our U.S. Constitution.
And Your Honor, would you like a brief statement of the facts?
Yes, could you please restate the facts?
Okay. In 2015, the Montana legislature enacted the Tax Credit for Qualified Education Contributions Act. The law allowed people to donate money to private nonprofit scholarship organizations and receive up to $150 in tax credit. One scholarship organization in particular, called Big Sky, sought to award scholarships to students at both religious and non-religious schools.
The plaintiff, who are mothers who attend Stillwater Christian School, wanted their children to obtain the Big Sky Scholarship. Now, this was originally possible up until the Montana Revenue Department Service issued Rule 1, which banned the scholarships from being used in even religiously involved institutions. Now, the rule was made in order to comply with their state constitution, and which outlawed the government from appropriate direct and indirect funds to a religious institution.
The plaintiff brought suit arguing that the original tax credit program was constitutional and that the additional Rule 1 was unconstitutional. They won a district court which found the original tax credit program to be constitutional while leaving the possibility that Rule 1 would be unconstitutional. On appeal to the Montana Supreme Court, the judgment was reversed and the court held that the original tax credit program violated the Montana Constitution and that the addition of Rule 1 makes the program constitutional.
Now, the Montana Supreme Court has already issued that it is against our state constitution. However, we're not going to argue that. We're going to argue that the Montana Constitution, again, itself is against our U.S. Constitution. And therefore, the reasoning behind the Supreme Court's decision in Montana cannot be used.
The Montana Constitution, Article 10, Section 6, says the government may not directly or indirectly appropriate funds to institutions which are even partly controlled by religion. This portion of the Montana Constitution goes against our U.S. Constitution for 2 reasons. One, the Montana Constitution goes against the Founding Fathers' intent by completely separating the government from religion. 2, the Montana Constitution unfairly discriminates against religious institutions while helping otherwise similar non-religious institutions.
So starting off with the first point, A complete separation between church and state was never the founding fathers' original intent. History up to that point, of course, had multiple examples of government violating unalienable rights in the mantle of religious purity, and the First Amendment served as a attempt to separate church and state. However, the founding fathers knew that a complete division between church and state was never possible, and it was never the intent.
So, Counselor, if I can interrupt briefly and ask you a question, is Montana obligated to provide any funding for religious schools? Do they have like a duty to put this money out?
No, they're not obligated to.
Okay. Why can't Montana decide to take extra precautions to prevent entanglement between religion? Why can't they decide to not fund religion? Why is that impermissible?
Well, because the legislator already said that was generally available fund. And furthermore, in Solomon already established that you can use funding for education as a secular purpose. And if you already give, the original tax credit program said that it was both religious and non-religious schools that get that generally available fund. So therefore, taking it away would constitute a free exercise clause violation.
Well, let me ask you a follow-up question, and maybe your co-counsel can answer this one. Arianna, how does this case differ from Locke v. Davey? Right? Isn't this scholarship similar to the unconstitutional program from Locke v. Davey?
In Locke v. Davey wanted the scholarship to pursue a theologian degree, and the Supreme Court told him that they were going to stay neutral in that case and not take Davey's side or the other side due to them not wanting to favor a religion over the law. But in this case, the benefit is being used for a secular purpose, not necessarily to push the religious agenda or for the students to receive a religious education, but necessarily for them to receive a normal education just with religious values in the background. But the primary purpose is secular.
Well, no, I get that, but I mean, are there going to be prayers said during the day at this school? Are they going to say some prayers?
Yes, they do, but they also do the main core 4 subjects that are also done at any public institution.
Well, then maybe there's a better answer. Maybe Montana could just limit the funding for, limit the funding for those 4 subjects: math, science, history, right? But not allow it to be for the school in general. Why can't Montana have a more targeted, more narrowly tailored scholarship program?
Because then it will become discriminatory on the basis of religion, because you're only allowing the scholarship to be given to secular programs in secular schools versus non-secular schools. That is why the first president of the United States found it reasonable to make Thanksgiving a federal holiday. Contrary to popular belief, Thanksgiving is not about the natives and colonists exchanging presents. The holiday, according to George Washington, was a day prepared to be observed by acknowledging with grateful hearts the many signal favors of the Almighty God. George Washington's Thanksgiving Proclamation. The proclamation goes on to say that the people on the last Thursday of November should all unite in rendering unto him, meaning God, our sincere and humble thanks. It is clear now that the thanks and thanksgiving is directed at God, and that the barrier between church and state is not as solid as it seems. Mm-hmm. That, however, doesn't violate the free exercise clause or the establishment clause, because the government isn't coercing you into celebrating the holiday.
Your Honor, to further illustrate this point, we may also look at the debate on the First Amendment. The original draft for the First Amendment was that no religion shall be established by law, nor shall the equal rights of conscience be infringed. Now, to this, Mr. Silverton actually expressed concern that the provision might be accidentally misinterpreted as having no religion, and Mr. Madison and Mr. Huntington then responded that the text should be written in such a way as to secure the rights of conscience. Mr. Huntington also additionally expressed concern that the text could be purposefully misrepresented as complete separation between church and state, which it is not. He then went on to provide an example of how the building of meeting houses was contributed in the same manner, and how having the government build these religious buildings could be compelled can be misconstrued as a religious establishment. The thought of through the use of Mr. Huntington's example, we can see clearly that the founding fathers did not intend for a solid and complete separation between church and state.
Well, let me ask you another thing. Can you tell me a little bit about James Madison and his famous memorial and remonstrance? What was that about?
It was mainly about the establishment of religion, and in James Madison's Danbury Baptist article, he says, if all men are by nature equally free and independent, all men are to be considered as entering into society on equal conditions, as relinquishing no more and therefore retaining no less one than another of their natural rights, being that their natural rights be rights they are born with that cannot be taken away, such as religion and or education.
I'm sorry. For Danbury Baptist, are you talking about Madison or Jefferson?
James Madison's memorial.
Yeah, that's what I thought you meant. Okay, very good. Well, but wasn't Madison worried about funding using government money for religious institutions? Wasn't that one of Madison's concerns in the memorial?
Yes, that was his fear, but his biggest fear was the government establishing a religion and forcing people to follow that religion instead of them being allowed to freely exercise the religion.
Is there any coercion going on in the Montana case?
May you repeat that, Your Honor?
I'm sorry. Is there any coercion in the Montana case?
No, there's no coercion because the government isn't forcing the... let me rephrase that. There is slight coercion on Montana's side because they're pretty much telling the students, the plaintiffs, that if they wanted to receive this Big Sky scholarship, that they would have to leave their religious background out of this factor to receive this benefit. And as it was stated in Trinity, people should not be forced to give up their religious freedoms and their religion to receive any government aid and or benefits.
Okay, very good. You may proceed with your arguments.
In Whitmire v. Vincent, the state of Missouri, similarly like the state of Montana in this case, argued that the denial of a religious entity was valid under the state interest of separation of church and state. In that case, Cornerstone Tree hosting a religious meeting in a state university was denied, despite the fact that other secular meetings were allowed. The Supreme Court's ruling was that Cornerstone's First Amendment rights outweighed the state's interest of separation of church and state. In achieving greater separation of church and state than is already ensured under the Establishment Clause of the Federal Constitution is limited by the Free Exercise Clause. The underlying purpose of separation between church and state is to chain the government from religious discrimination, both in Whitmire and in this case. The state discriminates on the basis of religion under the mantle of state purity and complete disentanglement with religion.
Your Honor, if I might add to co-counsel's point, it's basically like saying if there's a scale in which government can support a religion, the Establishment Clause is a cap. You cannot support religion more than this point. And the Free Exercise Clause is much more like a minimum. You can't hate on a religion up to more than this point. And the little area in between is gray area in which the government is allowed to operate.
Well, Counselor, let me ask you a question. Is Montana the only state with a no aid provision in its constitution?
I'm pretty sure other states have no aid clauses, but
and have those been around for a long time?
I'm not sure about that, Your Honor, but
I'll just tell you, they've been around for more than 100 years, right? But let me ask this question then. Why should the Supreme Court now declare unconstitutional these no-aid provisions that have been around for 100 years, right? Why should we come in now and say, no, never mind, you can't do this. We've been doing it wrong for a century. Why should the court intervene in that aggressive fashion?
Well, Your Honor, the problem isn't the no-aid clauses as a whole. We just have trouble with the indirect funding of religion. We agree that the direct funding of any church by the government is unconstitutional. However, we do not agree with that indirectly funding a religion is itself unconstitutional. If the main purpose is a secular purpose, and the aiding of religion is incidental to that state purpose, then it should be allowed, and it should be constitutional.
Okay, you have about a minute and a half left if you want to begin towards your conclusion, and then we'll move to your rebuttal time.
Moving on to our second argument is that by allowing the state constitution to continue, then that would be discrimination on the part of the state. In Trinity Lutheran v. Coleman, the Supreme Court held that denying a generally available benefit solely on account of religious identity imposes a penalty of the free exercise of religion. In this case, the Montana State Department imposes a penalty on Stillwater and its petitioners by not allowing them to receive funds based solely on the religious affiliation, and also as well as in link the government's actions cannot penalize religious activity, benefits and privileges enjoyed by other citizens. Multiple cases have been used where you can aid religion and you can indirectly aid religion and still be good with the First Amendment. In McDaniel, as stated in Trinity Lutheran, it required for them to not claiming entitlement to a subsidy and instead asserting a right to participate in government benefit without having to decide its religious character.
All right. Your 15 minutes are up. You can have another 5 minutes and proceed. And you can use that as to rebut or however you wish. You proceed.
So we rebut to what the other
yes,
opposing counsel.
Exactly. Yeah, right.
May it please the court. So I'd like to address some things said by opposing counsel first. That the constitutionality is actually on what is considered a generally available fund, and it's not up to the court to decide what's in generally available fund. It's up to the legislator, and the legislator already said that they allowed for money to go to religious and non-religious institutions. The addition of Rule 1 is what makes that constitutional, and we're going against what's considered a generally available fund. Second, the distinction between Locke and Trinity Lutheran is incorrect because in Locke, having to pursue a degree in theology was never a generally available fund, as it is today, where the tax credit program was already a generally available fund, and therefore taking that away is a violation of the free exercise clause.
And also to oppose what our respondent side said, it is discrimination because the treatment or consideration of or making a distinction in favor of or against a person or thing based on the group, class, or category to which that person or thing belongs, rather than on individual merit, is discrimination. The plaintiffs were eligible for this Big Sky Scholarship up until the point where they allotted to use the scholarship to attend a religious school. As long as the money is used for a secular purpose, it doesn't violate the Constitution whatsoever. Education is always going to be a secular purpose because that is the primary purpose of the school. Now, whether they pray on the side or not, we can't monitor them, but it shouldn't be a factor in this. And the Montana 10 Constitution says that they cannot indirectly or directly fund religion, but the rebates are citizens' choice of Montana to choose between funding public or private schools with the tax rebate. They aren't going to give their money to religious schools. It's not the government directly or indirectly funding the religious schools. It is therefore the citizens' choice and their money that is going to either or.
But isn't the Montana Constitution also part of the law here, right? Shouldn't we also think that the people of Montana ratified this amendment and said we don't want this money going this way? Shouldn't the Constitution affect your analysis?
I mean, it should. The whole Constitution in itself is unconstitutional because the legislators themselves accepted this program and passed it, and then as soon as it became about religion, they eradicated the program. We're not telling Montana that they need to. We're not telling them that the Supreme Court is going to force them to change it. We are asking them that if they would like to, they need to fix their own constitution within their legislators. The problem now resides in their legislators' hands.
Okay. Are you about a minute and a half left? Do you want to wrap up your arguments?
All right.
The state of Montana may not recognize that its constitution is harmonious with the U.S. Constitution as it pertains to the Free Exercise Clause. Therefore, the Montana Supreme Court may not use it to eradicate Big Sky. The Montana court overstepped its boundaries when it used Montana 10 to strike a program that the Montana legislature passed. The eradication of the tax credit program falls into the hands of the Montana legislature, not the Montana Supreme Court.
And Your Honor, the Montana Constitution is unconstitutional because of its failure to abide by the First Amendment of the United States, and also because of its discrimination against people with religion. Now, based on the reasons set forth, we pray that this honorable court reverse the lower court's opinion. Thank you.
Okay. Thank you so much, Scott. Thank you so much, Arianna. I'm very proud of both of you. These were not easy questions that we gave you. These are hard questions. And I think you handled them quite well. You showed a sophistication and a really deep grasp of some complicated cases. We expect the Supreme Court to decide this case any day now. And we may get a 5-4 decision. So there's a lot here. So we're very proud of both of you. Also, I'd like to thank your teacher, Mr. Seal, who has been a great coach and who's put together some really, really powerful contributions to this competition. Do you have any questions for us, Scott or Arianna?
Josh, I want to thank you and Sebastian for the time that you put into this. The fact that this thing gets judged, every round gets judged by you, Josh, and Sebastian, I don't know how many rounds you'll get to do, perhaps all of them. That's a huge time commitment from you guys. And we appreciate that.
Oh, I love this. It's a highlight of my year to be able to do this. As many as I can judge, I'm happy to do it.
Well, we appreciate it tremendously, and it truly does make the consistency, having just the two guys judge it, consistency makes this one of the most legitimate competitions of the year. And then the questions are always super well thought out and whatnot. Thank you very, very much for the time.
Thank you, Arianna. I think you put your thing on mute. Do you have a question for us?
Yes. What is the scoring system?
We have a rubric. We'll send you your scores. I don't know exactly when, but we'll send the scores at some point. I think I sent your teacher a copy of the rubric. Did I send you, Mr. Seal?
You did. Arianna, we shared it with each other yesterday. I'm not sure if you had joined the group yesterday.
Yeah. So basically, it's judged on it's judged on 4 dimensions. Your preparation, how you answered questions, your performance, and also your courtroom conduct. So you're judged on 4 main categories. Each category has like 4 subparts. We'll send you guys your scores a little bit later if that works for you. All right?
Yeah, that's great. We'll look
I think
forward
there's
to
a total of 17 criteria.
when we get those.
I think that's right.
Thank you,
I don't have it right in front of me right now, but we'll be happy to put the scores around a little bit later. And I'll put this video and also the other video on YouTube later today, so you can watch them later. Okay. Any other questions for me or Sebastian? Sebastian, is there anything you'd like to add?
Thank you so much for all participating in this. It was a joy.
Okay, thank you. I'm going to stop the recording now, and I will be in touch soon. Thank you all so much.